Sri Justice Rohit Khanna, former Judge Supreme Court of India, Honorable and Chief Justice Sri Vijay Khalsa, Honorable Judges of our High Court, learned senior advocates, government leaders, assistant government leaders, registrars, and members of the bar, distinguished guests and friends. On behalf of the Telangana High Court Advocates Association, I heartily welcome you all for the lecture on the state's power to tax overstretched limits, 2-9 bench judgment by Honorable Sri Justice Rohit Khanna, former Judge Supreme Court of India. Now I invite our Honorable President Sri Agyada Reddy Garu to adorn the chair on the dais. I request our Executive Member Ganapati Sri Khan to felicitate Honorable President by giving a bouquet. Now I invite Honorable Sri Justice Rohit Khanna, former Judge Supreme Court of India, to adorn the chair of the dais. I request our Vice President and Treasurer, Deepti Ma'am, and Shravya and Executive Member Sabina to felicitate our honorable guest by presenting a bouquet. May I now request our Honorable President Sir to introduce our Honorable guest today.
Honorable Acting Chief Justice Honorable Judges, Senior Advocates, Advocate General, Additional Advocate General, Additional Solicitor General, Public Prosecutor, Senior Designated Counsels, Government Leaders, Assistant Government Leaders, Senior Members of our distinguished guests and friends. On behalf of Telangana High Court Advocates Association, I heartily welcome you, sir, to our association to the lecture. Honorable Justice Rohit needs no introduction. Sir, born on 13/8/1956, Holy Sam Nariman, a distinguished jurist, and Bob C. Nariman. Sir married Sanya Nariman. Growing in Nariman and school education at Catholic School, Mumbai, and college education, Sri Ram College of Commerce, Delhi. Then Sir had obtained law degree from Delhi University. Then joined Harvard and obtained Sir enrolled in the year 1979, was member Bar Council of India, designated as senior counsel when he was 37 years old, making senior designate. The rule was amended by the Chief Justice of India. Later, Goenka and was the General Solicitor General of India. He worked since 27 July 2011 to 4th February 2013 and thereafter resigned. Subsequently, Sir was elevated as Judge of the Supreme Court of India directly 5th Advocate on 7th July 2014 and retired on 12th August 2021. Sir has written a book on Zoroastrian, the inner file. Sir is an expert in comparative constitutional law and civil law. Sir has set up a Supreme Court Welfare Trust, the welfare of lawyers, and to encourage the young talent in Supreme Court. Sir was a member of the Supreme Court Mediation Committee, and there are a number of judgments written by but few I just name and read. Shreya Singhal versus Union of India, sitting along with Justice Sharma sir, our combined state judge, and in fact, the most of the advocate fraternity had welcomed that judgment for defending the Indian Constitution, ideals of tolerance, and the constitutional tolerance of free speech. And the next important judgment, Triple Talaq, Sangamaram versus Union of India. In that judgment, 3:2 served on the side related to the Talaq. And Sabarimala case, you all know. Sir, it was taken, and according to Goenka, the bona fide criticism, I read from his bona fide criticism of the judgment, albeit highest court of the land, is certainly permissible, but thwarting or encouraging persons to thwart the directions or orders of the highest court cannot be countenanced in our constitutional scheme of things. And I think before his retirement, there's a Kutaswamy case where right to privacy accepted that it has derived from Article 21, etc. Sir, to take much time, I request you, sir, please address our association. Thank you.
Honorable Judges of the High Court, Mr. President, fellow lawyers, this is the third in a series of lectures which affect the nation. The first I delivered was the Amati Foundation lecture, where I spoke about the Ram Temple. The second I delivered shortly after, which was the Krishna Memorial lecture in Kochi, dealing with economic reservation and on the ground of economic poverty alone. And what is the remedy ultimately for reservation should it continue forever or otherwise? And today is the third, where 2 9-judge bench judgments directly impact the nation in the economic sense. Now these 2 9-judge bench judgments have both undone 2 7-judge bench judgments. The first is in the area of the mineral wealth of the country, which is Mineral Area Development Authority versus Steel Authority. And the second is in the area of industrial alcohol, which is again vital for the nation's economy. And that is called State of UP versus Bhavta Prasad Vaish. To begin with the first, that is the mineral case, it is important to realize that our constitution did not begin on a clean slate. A large part of it is taken from the Government of India Act of 1935. And In particular, Article 246, read with the 7th schedule, is almost directly borrowed verbatim from the Government of India, Section 11 and the second 97th schedule there. The 7th schedule consists of 3 lists. And when we talk of the 7th schedule, we are talking now of legislation. So we are talking of central legislation versus legislation by the states. Central legislation is covered by list 1. There is exclusive legislation given to the center, provided it belongs to a subject matter falling in an entry in list 1. Likewise, the same thing is done with the states in list 2. And then there is a concurrent list, which is list 3, where both the center and the states have concurrent jurisdiction over the subjects mentioned there. Today's lecture doesn't concern itself with the concurrent list at all. It deals only with list 1 and list 2. The principle of federal supremacy, which was accepted by the majority, is laid down in Article 246. Because 246 clearly states that where there is an irreconcilable conflict between an entry in list 2 and an entry in list 1 or list 3, the concurrent list, the entry in list 2 must be with, and this is referred to as the federal supremacy principle. Second, you have in each of list 1 and list 2, but not in the third list, general entries dealing with general topics of legislation, followed by taxation entries, properly so called. The taxation entries cannot be read into general entries as a result. And the same obtains for the state list or list 2. Now, for the mineral case, we are directly concerned with 4 entries which you must keep in mind at all times. Entry 18, first of all, in the state list, which says land, that is to say, rights in or over land. Then entry 23, which carves something out of land, because otherwise it definitely belongs to land. That is what is in the subsoil, the mineral wealth of the nation. So it says, mineral regulation and development, subject to, now this is very important, an entry in the central list, which is entry 54. Now this subject to is almost like a double federal supremacy principle. Because here there is no question of any clash between 2 entries. Here, the moment under entry 54, list 1, the center thinks that in the public interest, it is necessary to take over the entire or part of the legislative field dealing with mines and mineral development. The state legislatures have nothing to do with it once it is begun. So, the legislative entry 23 gets robbed of its content if under 54 there is a parliamentary declaration which says that in the nation's interest we wish to take over mines and minerals development. So far so good. Now in 1957, the Mines and Minerals Regulation and Development Act was enacted by Parliament. And that act very clearly enunciated by way of a declaration that we are proceeding to take over the entire field relatable to minerals and mineral development. It made the requisite declaration, followed by the sections, and in particular section 18, which showed that there was nothing left now for the states to legislate upon, insofar as mines and minerals are concerned. And this was in fact so held by a trilogy of cases. Mind you, the Act divided minerals into major and minor minerals. And it also gave jurisdiction to the states over minor minerals. But it's only because the center did so that they get that jurisdiction. Otherwise they get none. So we had a famous trilogy, first in 1961, followed in 64, and then followed in 1970. So we have the first case, and so in fact the first two cases come from this. And both are cold cases, so to speak. The first is Hikir Rampur Coal Company versus the state of Orissa, followed by state of Orissa versus Tulloch and Company. The facts were almost identical. There was an Orissa cess that was levied on mining, which was recovered at the pits mouth. And the question was as to first whether it was a tax or it was a fee. Now let me pause for a moment. A tax and a fee differ in vital respects, even though there was a bit of blurring in between. But there are at least two vital respects in which they differ. A tax is a compulsory exemption which you have to pay, dependent upon the activity that is carried out. It could be the earning of income, it could be the production of goods, it could be the sale of goods. The moment such a sale takes place, production takes place, income, the tax becomes leviable without more. In the case of a fee, on the other hand, there should be some special benefit that is given to the class of persons who pay the fee. Otherwise, you can't characterize it as a fee. And what is collected should not be too much more than what is defrayed by their expenditure for the benefit of those people. Now, the fundamental distinction, constitutionally speaking, between a tax and a fee, that taxes are clearly demarcated, as I told you. In the latter part of the two lists, this one and two. Fees, however, are attached to general and non-taxation entries. So that you find as entry 96 in list 1 and 66 in list 2. Fees relatable to matters that are laid down in this list, and likewise in this case. The question that the trilogy of cases was concerned with were fee cases, because ultimately they all held that the cess was not a tax, it was a fee. The second case in particular said that after the Mines and Minerals Regulation and Development Act of 57 had come in, the entire field where mines and minerals has now been taken over by Parliament. Nothing is left of the cess. The last judgment by Judge Kedia, which was in 1970, was a case from Bihar. And there the Bihar Land Reforms Act added a second provision, which purporting to deal with minor minerals. The court struck it down and said that whatever can be done with minor minerals, you have to follow the drill of the NMRDA and you can't go outside. One very important argument was made by Lalkar and Sinha in that case. And the argument was that in any case this is part of a land reform act. So, the relevant entry will be entry 18 and not entry 23. You remember entry 18, land, versus 23, minerals. This was turned down saying, no, it may have something to do with land generally, but specifically only with minerals. Since therefore it deals with something specific like minerals, you cannot characterize it as something being legislated under entry 18. This is important from our point of view. Now you come to the taxation entries in the statements. So far we have dealt with general entries and abstraction of the fee, and all fees therefore being leviable only by the sector. When you come to tax, you have entries 49 and 50. And they follow closely the general entries. Because 49 says taxes on lands and buildings. It's important that it is on, not in respect of. And 15, which is a peculiar entry, because it's only one of the taxation entries which is subject to limitations laid down by Parliament. Otherwise, the states have plenary jurisdiction to tax under this. And entry 50 says taxes on mineral rights, whatever that expression means, will come to in a minute, subject to limitations laid down by Parliament by law relating to mineral wealth. Now, with this in front of us, we have now another trilogy of cases which tell us what taxes on land and buildings mean. And there we have three judgments, one in 69, one in 70, followed by one in 71. One dealing with the Wealth Tax Act, one dealing with the Urban Land Tax Act, and one dealing with the Gift Tax Act. Each of them have arguments that were made, and ultimately the court found that entry 49, which speaks of tax on lands, is in essence a tax that has to be directly on land as a unit, which means it cannot indirectly relate to land. It has to be on land and acreage, and land as a unit, cannot concern ownership. So it's on property as against person. After these three cases laid this down, the width of entry 49 became clear to all. Now, entry 50, there was nothing direct except a dissenting judgment of Justice Vanchu in the first of the first three cases. He gave down. And then Justice Vanchu said that a tax on mineral rights in any case cannot ever be on the activity of money. So it cannot be related to royalty, for example, which is paid only when you actually mine. It is for the right to mine and nothing more. Now this is how it stood until a judgment called HRS Kurti versus the collector in 1964 put a spanner in these rules. So there the question was, there was a cess on land and annual rental value was defined as including royalty from mining and therefore calculable on royalty. Question was whether it was in substance a land tax or a tax on minerals. And Justice Rajgopal, I was speaking for 5 million tons. Here again it was a tax on land and said that in one of these sentence it was more directly connected with land than with minerals. So the report opposite, remember, of what was said in Vaishnav area, but a few years later, the area was later judgment in 1970. Now with these difficulties before us, a 7-judge bench was convened in India Cement case. And in India Cement, again, you have a section 115 of another Madras Act. In the 1964 case, which is case, you have a Madras District Court Act. Here this was another Madras Act, which purported to define land revenue now as including royalty. Same thing. And this time India Cement went through trilogy number 1, trilogy number 2, and ultimately said that look, this thing about Murthy saying that it is indirect way, minerals and direct way lands is absolutely wrong. It is in fact the exact opposite. And therefore, Murthy got overruled. However, in the process of overruling Murthy, the court also went into whether royalty itself was a tax. According to me, it was unnecessary. But they went into it because if it was a tax, then section 9 of the MMRP Act lays down limits. And then according to the court, therefore, those limits would apply because of entry 50, which if you remember, said tax on mineral rights but subject to limitation by Parliament. So anyway, finally, they quoted from 2 different points of view of the arguments and said, yes, royalty itself is a tax. Therefore, in any case, there are limits. And neither under entry 49 nor under entry 50 can you work. Important to remember. India Cement judgment was delivered in 1989. Parliament came out with the Cess and Other Minerals Validation Act of 1991. And in that act, what it did was to save the legislation made by 7 states. So it said in the schedule now be treated as parliamentary units. This is more difficult. And then they said, however, beyond 4th April 1991, which was the Odisha Civil Judgment, you cannot levy or collect taxes. So Parliament ultimately accepted what India said. And it was laid down now for all that from 4/4/91, the mineral wealth of the country would not be subjected to skewed taxation by the states, but only uniform taxation by the center. Mind you, the mineral wealth of the country is not only important for our own industries, but extremely important for export and import. And I will tell you that export contracts are very often, particularly with coal and iron ore, long-term contracts, where you have taxes built in, so you must be certain as to what the taxation is. Second, you are also competing internationally with others. So taxation levels cannot be crazily high, otherwise again, your product becomes uncompetitive, then you have to import this product. So it's very, very important therefore to remember this. Now this position continued and we thought that everything was settled now, once and for all, in accordance with the scheme laid down by the Constituent Assembly. However, in 2004, in the state of West Bengal versus Kesoram Industries, you had a 5-judge bench now. Don't forget, India's Senate was 7. A larger bench always binds the smaller bench. The judgment in Kesoram found that according to it, there was a typographical error in the 7th judgment. What was meant was not that royalty was a tax, but that cess on royalty was a tax. And therefore, they said, this typographical error, we will therefore interfere with the ratio of this judgment. And the typographical error must be there, the whole judgment would have been different, which is incorrect by the completely incorrect. And they finally upset in a combination of 5 what was said by 7. And they went back to the Mufti position, saying that all taxes which are based on cesses based on royalty can be justified either as land taxes under 49 or as taxes on mineral rights under 50. Now, one very important thing to remember is, even assuming there was a typographical error, first and foremost, that becomes an error apparent on the face of the record, which you can correct only by review. That was never done, and the review would have to have had to be before 7 learning. So, according to me, the entire exercise in Kesoram's case ought to have been ignored, and it should have been said that this does not lay down a binding precedent at all, because it could not have undone what 7 learning judges did. Even otherwise, assuming royalty not to be a tax now, it certainly could not have undone the other issue, which was a separate binding issue, which said that when there is a cess on royalty, it has reference to something special mining and not something general land, and therefore it must go. Now, because of Kesoram, certain states again started raising their heads and started taxing the mineral wealth of the country, like the road opening, the bad opening, the revenue. And these matters then came to a head and were referred to 9 learned, which is now how to have the 9 learned bench judgment of 2024 delivered by the learned chief justice. The only silver lining I might tell you in both the judgments is that Justice Nagaran is and her dissent is forceful and logically completely correct. So what is Mineral Area Development Authority now? Mineral Area Development Authority relooks at the entire conspectus of provisions that just shown, cases that I just shown, and then says that no, a tax on mineral rights cannot be construed in a narrow pedantic fashion. Mineral rights means everything to do with the mineral. In short, you almost made it a tax in respect of minerals. Rights was ignored, not was ignored. Vital words in NPV. tax that can possibly be conceived of from the time that the mineral comes out of the mine till the time it is ultimately consumed or within this entry in any case. Secondly, there are no limitations laid down by Parliament because royalty is not a tax. People for the time being forget about royalty, whether royalty is or is not a tax according to the famous titles. So in 350 then became one area within which you could house this. What went on further, it didn't stop. It then went on to say, and here it wrongly relied upon two earlier judgments. One was a judgment recorded in 1975, and the second was an earlier judgment in Ajoya Kumar Mukherjee's case. Now in Anand Mills, there was an Ahmedabad electricity company that had laid underground electric lines, and property tax was demanded for them from them on the footing that they were occupiers of that. Ultimately, the court said land includes everything over and under the tax. Of course it does. And then said, therefore, you must pay that property tax. Now, this was brought in by the learned judges to say that since everything under land belongs to land, minerals being under the land are also part of it. Forgetting completely the scheme of the Constitution, which is that minerals have been carved out, as I told you, in entry 23 from land, which was entry 18, general, special. And again forgetting that the taxation may both also follow the general entry. The moment you ask us a question, what is a tax on land? You have to understand what land is first. And to understand what land is, you have to go to entry 18, which is the general. The court, however, divorced it and said, no, the general entry has nothing to do with taxation. Then, however, it went on to say, following the Guthrie group, which was a key group of cases, in key dispatches, that Ajoya Kumar Mukherjee's case, which was the second case, dealt with markets and therefore dealt with land being put for a particular user. Now, if you put land for a particular user, you can use that user as a measure of taxation. And therefore, they say, if you use royalty as a measure of taxation for land, then there is a nexus between that user, which is for mining activity, and land, which means the tax. The first problem with this is that land is immovable. You can't ever forget that once a mineral is removed from the land, it is no longer part of the land. It is movable property. It is goods. So if you seek to confuse immovable property tax with an immovable property tax, then you are right. You cannot do so. First. Second, they forgot that taxes are taxes directly on land as a unit. Now take a case where there are three adjacent lands. Each of them have coal streams, the same coal stream. In fact, they've been carved into three separate units with three different owners. Now the first owner doesn't mind at all. So he's paying 10 rent. Assume the net rent is 100 rupees for the year. The value of the land then becomes a percentage of 100 rupees. Assume that the second land now is owned by somebody else, and that somebody else is utilizing this particular coal and is mining it and pays, let us say, a royalty of 1,000 rupees. The percentage of royalty then on 1,000 will become 10 times that of their land. And the very land, therefore, which is next to the land on next to it, let's say plot A, plot B, cost 3. Plot B today will be valued at, let's say, 1,000, and plot A at 100. Plot C, where the person is exporting and has to fulfill an export contract, is actually mining 1,00,000 tons. So immediately, his land then becomes most valuable, and the percentage of 1 lakh or whatever it is now becomes a value. Because obviously, when something is to reflect the value of land as a unit, that something has to be the same. The same land cannot, depending on mining activity, either become worth 10 rupees in a particular year or become 1 lakh rupees. Same thing. Let's say the second year, for some reason, the 1 lakh man becomes a 10 rupee man. Can we say the property price has now become zero? So, obviously, in my respectful statement, I would think that the link that is between royalty and land is snapped by two things. One, the fact that it is movable as opposed to immovable. And second, that it does not reflect the value of land at all. Now, with this, Justice Nagaratna has a very vigorous dissent. First and foremost, she defends her father's judgment, as a Mysore, with all the vigor of a very faithful daughter, saying that a tax, the royalty is definitely a tax. And she spends, let us say, 70% of her time saying that royalty is a tax. And that from that it followed that Section 9 of the NMRD Act in any case is something which interdicts the states from going beyond what you can fix as royalty. Then she tackles the other thing. And she says, quite correctly, that when you have a general entry and a specific entry, right, land and minerals, obviously minerals are carved out of that. They may generally, in some other context, be part of that. Yes. But in this constitutional scheme, they are obviously not part of that, because land you cannot touch, Parliament cannot touch. It's a plenary subject matter for legislation by the states. Remember, you have the urban land ceiling act, for example. Now, even urban land is part of that. Parliament couldn't touch it. Parliament could only enact by virtue of Article 252 the urban land ceiling act, because the states themselves ceded legislative competence to Parliament for urban land. So this distinction was not kept in mind. That whereas land is something which is outside, completely outside Parliament's scheme, just as agriculture is, you find every single entry, whether taxation or general, are very, very clear in saying agriculture cannot be touched by Parliament. There is only one entry in the concurrent list, entry 41, which says that when you are talking of evacuee property, it will include agriculture and otherwise. The exact obverse is true of the mineral wealth. And despite all that, today, we are now told that a tax on mineral rights includes every kind of tax in and around the mineral. Except, of course, that it cannot be an excise duty or a sales tax. I don't know what that means, where that leaves us. And secondly, that in any case it's a tax on land. And the moment you say it's a tax on land, you have turned the constitution on its head. Because the very entry 50, which is subject to parliamentary limitations, is now completely wrong of that one limitation. And the idea is that the mineral wealth of the country cannot be touched by the states because it is so important for the region. And this is again played up by Justice Nagaratna. Justice Nagaratna tells us how important it is for the nation, how important it is for export earnings, how important it is for the industries that are to be run in the country, etc. And then finally says that therefore I am very respectful. Now this does with the first part. The second part gets even more interesting. The industrial alcohol. When we come to industrial alcohol, you have entry 52 in this one, which deals with industries generally. And something like 54 in that it says that when Parliament wants to take over by a declaration a particular industry, it says so. And then the state is denuded of competence completely. under the corresponding entry 24. So we have to see 52 read with 24. Also have entry 7 which means defense industry. Now, we are directly not concerned with these entries. But these entries led to the birth of the Industries Development Regulation, just like the NMRK. And that act was enacted in 1951 immediately. And various industries were taken. And in 1956, an item 26 was added, which said fermentation industries, taking in industrial alcohol. Now, industrial alcohol is again crucial to the nation's development for two reasons. One, it is a raw material for the chemical industry generally. Second, it gives you ethanol, which is a green fuel. And therefore, it saves foreign exchange. Unlike in the liberal case where you earn foreign exchange, you don't have to import ethanol. And the IDR Act has many restrictive provisions, including the centre's control over these important industries under section 18 capital G. And 18G says that the production, pricing, etc. of all these vital industries can at all times be controlled by the central government. Suppose there's scarcity somewhere. You can directly say, UX will produce and give to Y. You can also directly say you can get at such and such price. There may be scarcity due to an earthquake. There may be scarcity due to acquisition. All these things are dealt with then by the central government because these industries are vital for the nation's development. Now, fermentation industries was added, as I told you, way back in 1956. The entry with which the court was concerned, however, was not these entries. It was entry 8, which said intoxicating liquors. That is to say, production, manufacture, possession, transport, purchase and sale. And it's repeated, of intoxicating liquors. Now, we have three expressions in stream of constitution. We have intoxicating liquors in entry. We have in entry 47, which is the directive principle of state policy. Intoxicating drinks. And you have in the excise entry 51 list, alcoholic liquor for human consumption. Now, why are these three different? They mean the same thing, they mean different things. It's very difficult to say intoxicating liquors and intoxicating drinks mean something different. The essential thing is the verb to intoxicate. So whether it's a liquor or a drink, it must intoxicate in essence. And alcoholic liquor, however, could be right. Because it could be a liquid containing alcohol, which may not be ingested by a human being at all. Which is why it is qualified by for human consumption. That's why 51 speaks of for human consumption. So at the end of the day, all three things mean the same. However, the learned Chief Justice found other things. What the learned Chief Justice and several other learned judges found, that we will go by the Abtari Acts. All of them included ethyl alcohol, which was denatured, and in that sense was not potable. That was included within the Abtari Acts. Intoxicating liquor, therefore, had a much wider meaning, and it had the meaning ascribed to it by Bansara's case, which was the 1951 judgment of the Supreme Court, which said it doesn't need to be ingested at all by human beings. It could include industrial alcohol because it only means liquids containing alcohol. Now, Bansara's case was obviously wrongly decided for one very basic reason. Entry 31 in this 2 was unlike entry 8 of this 2 of the government of India. The predecessor government of India didn't just speak of intoxicating liquor. It also spoke of narcotic drugs, other narcotics, opium and heroin. And Justice Fazal in 1951 had to construe that entry, 31. Now obviously, a if you see intoxicating liquor along with the other four engines, what becomes crystal clear is each one of them basically dulls the senses. In each one of them, first, it's a human being who ingests. Second, the common quality is that it dulls the senses. So for that basic reason to say, an intoxicating liquor here, cancel the word intoxicating and say all liquids containing alcohol, would in my spiritual submission. Anyway, Justice Fazal Ali's vision found its way into a two-judge bench in State of versus Delhi Circular. That got twisted. And finally, 7 learned judges, just as in India's held that Balsara's case was wrong and ultimately said intoxicating become nothing more or less than potable alcohol. Now the excise entry also tells us a very interesting story, which was not examined by either majority or minority. The excise entry 51 specifically said that alcoholic liquors for human consumption may levy in the state standard. You may also levy on opium, Indian hemp, narcotic drugs and other narcotics. But you may not levy on medicinal and toilet metals. The Government of India Act was the exact opposite. It said you may levy also on medicine and toilet metals. Why did the Constitution, therefore, make this difference? It obviously made the difference because it wanted to put potable, ingestible alcohol and other narcotics together for taxation and leave it to Parliament to tax things which were not potable and which became therefore industry. Now the Industrial Regulation Act, as a matter of fact, has a separate entry 22 which specifically speaks of drugs. The entire drug industry is in 22. Just as the fermentation industry is in 26. And in 29 you have the cosmetic industry. So medicinal falls under drug, cosmetic industry is therefore. The scheme was very clear. Despite this scheme, again, the majority said tax entities have their own life. They have nothing to do with tendering. Result therefore, we have a very skewed thing now. We have excise duties only on potable alcohol. But so far as the general entry is concerned, it subsumes everything, including industrial alcohol. The reasoning of the court was based on one other thing. It said the entry said intoxicating liquor, that is to say. Now that is to say is not exhaustive according to the majority. It is only illustrative. And when it's illustrative, it would include alcohol which is used as a raw material for analysis. Again, completely wrong according to me. Now, with all this, Justice Rangratna again gave a very, very interesting statement. She made it clear that the line was drawn at potable, non-potable, which is obvious. If you just look at the entries carefully, it is obvious that beyond potable you cannot. But the effect of the majority judgment now is to cut out entry 26 in the IDR Act altogether. It's a very far-reaching effect. So what happens now is, with entry 26 gone, there is no control whatsoever by the sector over industrial alcohol. So the result of the 9th bench judgment is, each state can deal with industrial alcohol as it thinks fit. Second, in the guise of what is called a wet fee, what they really do is to tax now industrial alcohol as the parting of a privilege. Remember, there were a number of cases which said, in potable alcohol, that you have no fundamental right. It's a privilege of the state. And therefore, wet fees there are perfectly normal. So, two immediate consequences are, you have a skewed taxation by industrial alcohol, and again, the nation's economy goes for a 6, as Justice Rangratna pointed out. And the second obvious thing is, again, to industrial alcohol, you are now able to levy what is called event fee. And that is where synthetics and chemicals 7 judges were mentioned. Now, given these two judgments and given their deleterious effect to the economy, Justice Nagaratna's dissents in both is an appeal now to the brooding spirit not only of the courts but also of Parliament. Because Parliament will want to write this. The only trouble is that there will have to be constitutional amendments that will happen. Because entry 49 will have to be subjected now to the same limitation as entry 50. Because that's become a fertile ground for taxation of minors. And likewise, intoxicating liquor will have to be replaced with tobacco. Both of which can only be done through a very difficult process. We have covered third majority in both houses, followed by ratification of after states, because it deals with entries in residential. But nonetheless, at least one bold and brave judge has shown the way. And I may only end by saying, better sooner than later, either by the courts or by Parliament. Thank you.
That was a great enlightening speech by Sir, lecture indeed for all the faculty members, for which we've been waiting since last 4 months. Thanks a lot, sir. I request my brother secretary, Sanjeev Jeopardy, President of the Thanks.
Good evening, all. On behalf of the Telangana High Court of Association, I give it the privilege to propose a thanks. I thank Honorable Mr. Justice Mohinder Pali Supreme Court of India for accepting the invitation and pressing the power on the occasion of District Court Association. I thank Honorable Chief Justice Jeopardy and Honorable Judges of High Court for the State of Telangana and members of the legal for attending this occasion. Thank you, Honorable, for raising the occasion. I request all the members to join the meeting to guard us, please. Thank you.